Alessi. Good morning, Ms. Giannetti. Good morning.
Good morning, Your Honor.
Good morning, Ms. George. Good morning, Ms. Reed. All right, and good morning, jurors. My name's Beverly Canoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on how we think your day will shape up. You're here for impanelment in a criminal case that you've heard, and we appreciate you being here. Jury service is one of the most important civic duties that we have, and we understand that we're taking you away from your families or jobs, and we really appreciate that you're here, ready, willing, and able to serve if you're called upon to do so. And we also appreciate your patience with this proceeding. So this is the case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. The defendant is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death. I will describe those crimes in greater detail at the end of the case when I teach the juror the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that Ms. Reed committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are. Where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that Ms. Reed is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, The rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask questions to you all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you're not selected for jury service on this case, please don't take it personally. Don't think that somehow we think you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and perhaps picked on another case later. In a few minutes, I will pose a number of questions to you as a group. You have taken an oath that requires you to truthfully answer those questions and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out. You don't need to get your cards out yet. I'll tell you when you can, when we need to have those cards out. So you hold the card up in the air until the court officer can read the question posed to the group overly intrusive. You may elect to answer that question at sidebar. I will have additional questions for you which relate to issues that may be raised in this trial and are designed to give us more information regarding your ability to serve as a fair and impartial juror, and the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer. We simply want your best and honest answer to the questions. I'm now going to ask the lawyers to introduce themselves, and I'm going to ask counsel for the defense to introduce their client. Starting with the Commonwealth, please.
Thank you, Your Honor.
Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me, your colleagues.
Good morning. My name is Laura McLaughlin. I'm the Assistant District Attorney for the Norfolk District Attorney's Office. Welcome. Good morning. Thank you for being here.
Good morning. My name is Adam Lally, Assistant District Attorney with the Norfolk County District Attorney's Office. I represent the Commonwealth. Thank you for your time and attention today indeed.
Good morning, ladies and gentlemen. My name is Alan Jackson, and I have the honor and privilege to represent Karen Reed, who is standing to my right.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning. Thank you for coming and for your time today. My name is Robert Alessi, and I have the privilege of representing Ms. Reed.
Good morning. My name is David Unetti. I'm an attorney. I have offices in Boston and right here in Dedham. It's my honor to represent Karen Reed.
Good morning, ladies and gentlemen of the jury. I'm Victoria George, and I have the privilege of representing Ms. Reed.
Good morning, I'm Karen Reed. Thank you for being here.
Okay, thank you all. Folks, I'm going to read the witness list to you. There are a lot of names on this list. It doesn't mean that each one of these people will be called as jurors. It just means that you may hear their names referenced during the course of the trial. So it's important that you listen closely to the names. At some point soon, I'm going to ask you whether you know any of these folks. So please listen carefully. They're alphabetical by first name. Aidan Kearney from Jefferson, Massachusetts. Dr. Isaac Wolf from South Miami, Florida. Alfred Lopalato from Canton. Allison McCabe from Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, PhD from Pittsburgh, Pennsylvania. Angela Malvone from Canton, Mass. Annie Chung, also from Canton. Anthony Flamati from the Canton Fire Department. Ashley Bell, Canton. Ashley Villier from the State Police Crime Lab. Brian Albert, Norwood. Brian Albert Jr., Boston. Brian Higgins from Sandwich. Brian Loughran from Canton. Brian Wanless, who is retired from the Canton Police Department. Bridget Meehan, keeper of the records from Canton. Caitlin Albert from Easton. Lieutenant Charles Ray of the Canton Police Department. Chief of the Canton Police, Helena Rafferty. Chris Van E., who is a PhD from Novi, Michigan. Christina Hanley from the State Police. Christopher Albert from Canton. Christopher Curran from Canton. Colleen Crawford from the Norfolk DA's office. Colin Albert from Canton. Courtney Proctor, Canton. Kurt Roberts, Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, who's a PhD from Penns Park, Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell from Los Angeles, California. Dr. Elizabeth LaPosada, who's from Providence. Elizabeth Proctor from Canton. Eric Hanlon, Canton. Erin Beatty, Canton. Erin O'Keefe from West Bridgewater. Francis Walsh from the Canton Fire Department. Garrett Wing from Green Cove Springs, Florida. Gary Fowler from Brockton. Gregory Woodbury from the Canton Fire Department. Gretchen Voss from Boston. Hannah Knowles from the State Police Crime Lab. Heather Maxon from Walpole, Mass. Erabito Hernandez from the Boston Police Department. Holly Price from Mountain View, California. Ian Whiffen from Vienna, Virginia. Dr. Irene Scorti-Bello, she's from the Office of the Chief Medical Examiner, Massachusetts. James Crosby, who's a PhD from Jacksonville, Florida. Janet Reed from Dighton, Mass. Jason Becker from the Canton Fire Department. Jean Demoulas from Canton. Jennifer McCabe from Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe Sr., who lives in Braintree. Judson Welcher, who's a PhD from a company named Aperture LLC. Julie Albert from Canton. Julie Nagel from Canton. Justin Rice, who is a physician from South Weymouth. 2 juveniles from Canton, one of whom has the initials KF and the other is PF. Caitlin Boudreau from Raynham. Karina Kolakithas from Canton. Katie Camerano from Canton. Katie McLaughlin from the Canton Fire Department. The keeper of the records for Ring from Hawthorne, California. Kerry Curran from Canton. Kerry Roberts, Canton. Kevin Albert, Canton. Kevin O'Hara from the Mass State Police. Lance Mello from the State Police Crime Lab. Laura Sullivan from Pembroke. Laura Cahill from Worcester. Leslie Pearlstein from Canton. Lieutenant Michael Lant from the Canton Fire Department. Louis Jutras from Canton. Lieutenant Brian Tully from the Mass State Police. Lieutenant John Fanning from the Mass State Police. Lieutenant Paul Gallagher from the Canton Police Department. Maggie Gaffney from Bonita Springs, Florida. Mark Lopalato from Canton. Margaret O'Keefe, also from Canton. Marietta Sullivan from Pembroke. Mary Souza from Dighton. Matthew Amory from Canton. Matthew DeSogra from Charlotte, North Carolina. Matthew Erickson from Grosse Pointe Farms, Michigan. Matthew Kelly from the Canton Fire Department. Matthew Kelsch from the FBI. Matthew McCabe from Canton. Maureen Harnett from the State Police Crime Lab. Megan Mariani from New York, New York. Michael Camerano from Canton. Michael Easter from Los Angeles. Michael Trotter from the Canton Public Works Department. Michael Wagner, Foxborough. Mike Maroli, Bridgewater. Mike Rushworth from Thompson Station, Tennessee. Natalie Wyweek Berschneider from San Marino, California. Nathan Reed from Raynham. Nicholas Bradford from Lorton, Virginia. Nicholas Curran from West Roxbury. Nicholas Kolakithas from Canton. Nicole Albert from Norwood. Norfolk County District Attorney Michael Morrissey. Officer Kelly Deaver from the Boston Police Department. Officer Nicholas Barrows from the Dighton Police Department. Patrick Haggerty from Somerset. Paul Mikowski from Melrose. Paul O'Keefe from Canton. Rebecca Bisen from Canton. Rebecca Trayers, Norfolk. Dr. Renee Stonebridge, she also is from the Office of the Chief Medical Examiner in Boston. Richard Green from St. Pete Beach, Florida. Richard Donatno from Canton. Robert Gilman from Hull. Ryan Nagel, Canton. Sarah Levinson, Canton. Sergeant Brian Gallerini, the Needham Police Department. Sergeant Sean Good, the Canton Police Department. Sergeant Paul D. Giampetro from the Canton Police Department. Sergeant Yuri Buchanan from the Mass State Police. Shannon Burgess from South Lake, Texas. Cheryl Waugh from Canton. Sophie Herzan, the State Police Crime Lab. Stephanie Devlin, State Police Crime Lab. Stephen Mullaney, Canton Police Department. Steve Nelson, the Norfolk County DA's office. Stephen Bernstein, who is a keeper of the records from Stoughton. Stephen Ridge, the Boston Police Department. Stephen Seraph, Canton Police Department. Stephen Scanlon from West Roxbury. Terry Kuhn from Davis, California. Tess Chart from Lorton, Virginia. Thomas Beatty from Canton. Thomas Kelleher from Canton. Thomas Martin from Weymouth. Timothy Nuttall from the Canton Fire Department. Tristan Morris, Easton. The following people are Mass State Police troopers. Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Guarino, Trooper Zachary Clark. Wendell Robery from Canton, and William Reed from North Dartmouth. I'm sorry. North Dighton. So those are the list of witnesses. You're likely not to hear from all of them, but you will hear from many of them. And you can tell that this case is going to take a while to try. So we're in the process of impaneling a jury. We don't know how long this process will take. Once we get a jury, the lawyers tell me that their best estimate is that the evidence in the case will take between 6 and 8 weeks for the evidence. What we do is every day I will let you know if at the end of the day if the case is on track or a little ahead of schedule or behind schedule, and I have never had to say that we were behind schedule in a case. So we all appreciate your time and know how long this will take. So we do everything we can not to waste any of your time. There'll be a few days off here and there sprinkled throughout this long trial. The schedule that we will have is we will start each morning at 9 o'clock. We'll take a break around 11 for 15 or 20 minutes. Lunch will be about 45 minutes. We'll have lunch brought in for you folks so that you don't have to walk down and take any longer than we need. And we'll have it brought into you every day. Then we'll go after lunch until about 4 o'clock each day. So that's the schedule that we have. It's a good faith estimate. Sometimes trials go longer, sometimes they go shorter, but it's the best estimate that we have regarding how long it will take. So it might help now if I give you a preview about some basic law that applies to all criminal cases. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the very important legal principles that will govern this trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner in which to get a case against a person who's accused of a crime to come to trial in the Superior Court. But it is only the jury, in other words, you folks, who ultimately decides whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find Ms. Reed not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all of the evidence. Another important principle of law is that the defendant has an absolute right than not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, "You accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word." The jury must not consider in any way the fact that a defendant testifies or not testifies, because it has nothing to do with the question of whether she is guilty or not guilty. The jurors must determine whether the Commonwealth has proved its case beyond the defendant, beyond a reasonable doubt, based solely on the testimony of the witnesses and the exhibits introduced at trial. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in a case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law, instead of upon unsupported assumptions. Fourth, as you listen to testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of this case, I will remind you of these strategies and ask you to focus on the evidence instead of on any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it is confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So please don't be worried if you didn't catch everything I said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So, for jury selection, it's important to know if any of you might have some doubts about whether you can accept and follow these legal principles. So now I'm going to ask you to take out those white cards, please. But before we begin, I understand that sometimes jurors do not fill out the juror questionnaires completely, that sometimes we're in a hurry to get those questionnaires in, or sometimes we think that our situation may not apply to the question that's being asked. So if you know now that you've left something out of the jury questionnaire, tell us at sidebar. Jurors often leave out by mistake things like prior service in the jury, prior experiences in court as a litigant, as a witness, as a criminal defendant in a case. If we notice that your name is not there, if there's an employment history missing, we'll ask you. But if you know in advance, please let us know when you come up to sidebar. All right, my first question. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I read out?
Juror number 575, juror number 592, juror number 564, juror number 595, juror number 593, juror number 572.
Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County District Attorney's Office?
Juror number 595.
Thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome?
Juror number 568.
Thank you. If you have seen, heard, or talked about this case, please raise your hand now.
Juror number 576. Juror number 569. Juror number 562. Juror 589. Juror 596. Juror 606. Juror 563. Juror 571. Juror 572. Juror 586. Juror 550. Juror 603. Juror 578. Juror 607. Juror 569. Juror 562. And Juror 577.
Juror 555. Juror 599. Juror 559. Juror 568. Juror 581. Juror 564. Juror 595. Juror 600. Juror 574. Juror 561. Juror 565. Juror 602. Juror 566. Juror 582. Juror 601. Juror 553. Juror 597. Juror 575. Juror 609. Juror 592. Juror 594. Juror 593. Juror 584. And Juror 558.
Thank you. Please raise your hand if you've expressed or formed any opinion with respect to this case.
Juror 562. Juror 563. 606, Juror 586, Juror 563, Juror 571, Juror 572, and Juror 576.
Juror 555, Juror 599, Juror 559, Juror 568, Juror 564, Juror 595, Juror 600, Juror 574, Juror 561, Juror 602, Juror 566, Juror 582, Juror 601, Juror 553, Juror 575, Juror 592, Juror 593, and Juror 584. Sorry, 602.
Thank you. Are any of you folks aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? Please raise your hand.
Juror 595, Juror 555, Juror 599, Juror 559, Juror 568, Juror 564, Juror 602, Juror 566, Juror 582, Juror 598, Juror 593, Juror 584.
Juror 576.
All right. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
Juror 577, Juror 569, Juror 607, Juror 550.
Juror 561, Juror 600, Juror 611.
Thank you. Would any of you folks have any difficulty understanding and following those very important constitutional principles that I've outlined for you? First, that the burden of proof rests entirely on the Commonwealth. Second, that the burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden to do anything. She doesn't have to testify. She doesn't have to present any evidence. Her lawyers don't have to ask a single question. Anyone that would have difficulty following those very important constitutional principles, please raise your hand.
Juror 561.
Thank you. I can tell you folks that after every trial, I talk to jurors, and they tell me that not only was their jury experience an interesting one, most times they tell me that it was a very rewarding one. But I do understand that for some of you folks, serving on this jury may be an undue hardship. Let me tell you what I mean about that. Every civic duty we have causes us to be inconvenienced. An undue or a substantial hardship is much greater than that. It means that it's something personal to you so that you don't serve, but the person next to you has to take your spot. I generally think of it in terms of if you're a student or if you have airline tickets or surgery scheduled for the period of time that we'll be in trial. But I will hear anyone who thinks they have a substantial hardship. So if you think you fall into that group, please raise your hand now.
Juror 589, Juror 596, Juror 569, Juror 562, Juror 577, Juror 607, Juror 578, Juror 603, Juror 590, Juror 572, Juror 571, Juror 576.
Juror 611, Juror 598, Juror 595, Juror 553, Juror 581, Juror 568, Juror 566, Juror 559, Juror 599.
Juror 561, Juror 574, and Juror 575.
Thank you. All right, I'm going to leave the bench in a minute to give you a chance to fill out the questionnaires. I ask that you not talk to anyone as you fill out these questionnaires or share any information with the prospective juror regarding any questions or comments or concerns you may have about jury duty in general or jury duty on this case. So we'll get you those forms and we'll see you in a little while.
All rise for the court, please.